Any mention?
Please, Lordship, I beg to mention item number 14. Lordship, that this matter is connected with the division bench, Lordship. And Lordship may list this matter as and when the division bench matter is disposed of, with liberty to the parties to mention.
How do you say? That is already recorded. This matter is connected with pending.
Because that division bench matter is listed on 29th
29th
of July, Lordship. So
we'll have it after 3 weeks. Then. Just say
of
just
4
see the
weeks,
last
Lordship.
order. The parties submit that connected matter pending before the division bench is yet to be disposed of. We have the submission. This is matter.
That will be after 4 weeks.
After 4 weeks. Make it after 4 weeks. Yes, after 4 weeks.
After 4 weeks. Obliged.
See the last order and just.
My lord, I beg to mention item number 15, my lord.
Yes.
I'm praying for 2 weeks' time, man.
Well, this is also 2019 matter.
No objection.
This is what this relates to what this is.
This is service matter, my lord, that the petitioner hearing was not successful in the selection. So therefore they are challenging.
Just on prayer made by Mr. Arvind Landed G. Not objected to by the Lana Council for the petitioner. This is matter after when?
After 2 weeks.
After 2 weeks.
Deploy.
May it please Your Lordship. Your Lordship, I beg to mention item number 17, Your Lordship.
Yes.
Your Lordship, I humbly pray that the matter may come up after 2 weeks, Your Lordship.
Who is the respondent here?
I'm the respondent, District Council, my lord.
But another Nokma matter.
Yes, Your Lordship.
Any objection? No objection.
No, I have no objection.
Just try the same thing on prayer made on behalf of the petitioner, not objected to by the Lana Council for the respondent. List after 2 weeks.
2 weeks, Your Lordship. Your Lordship, similar prayer for item number 25, Your Lordship.
Who is the respondent in item 25?
25.
I'm appealing for the sole respondent, Your Lordship.
Any objection?
No objections.
This is 25 on prayer made on behalf of the petitioner. List after 2 weeks. Yes.
Highly
Please, Your
obliged.
Lordship, I beg to mention item number 19. I'm appealing for respondents 3 and 4.
Yes.
I appeal for 2 weeks' time, Your Lordship, in this matter.
Who is the petitioner here? Item 19. Have you informed?
Mr. Paul's chamber is the petitioner, Your Lordship, in this matter.
There is no one. So what is to be done?
He's here, Your Lordship. 19.
Lordship. No objection, Lordship.
Just on prayer made on behalf of the respondents. You are appealing for respondent number? All the respondents?
3 and 4, Your Lordship.
Three. The GHDC is also a party here. Okay.
Yes, Your Lordship, GHDC also is a party.
This is matter after 2 weeks. Yes.
Bless you, Lordship.
May it please Your Lordship. Lordship, I beg to mention item number 20 on behalf of Judicial, Lordship.
Yes.
Lordship is still recovering, so I pray for 2 weeks' time, Lordship.
No objection, Lordship.
20 on prayer made on behalf of the petitioner. List after 2 weeks. Yes.
Obliged, Lordship.
Lordship, I beg to mention item number 26, Your Lordship.
Yes.
I have no objection, Your Lordship.
It will come after 2 weeks. 2 weeks, Your Lordship.
Yes. Item 26 on prayer made by. You are appearing for the
Respondent number 1, Your Lordship.
prayer made on behalf of prayer made by Mr. Pala Landed G. Landed Council appearing for the respondent number 1. This is matter after 2 weeks. Yes.
Obliged.
Obliged, Your Lordship.
My lord, item number 23 and 24, my lord. The appellant has already, my lord, summed up with the argument, my lord. I'm not prepared today. I pray for 1 week time.
My lord, it's been quite some time. I finished my argument and states have been taken in the.
This is the first time I asked.
No, my
That is that parking related.
Yes, yes, yes.
yes, my lord. My lord, if
A week time, my lord.
They are seeking time again and again, my lord. Kindly consider of releasing them on bail first, my lord. Because why? Because, my lord,
Even for releasing bail also you have to go on by merits, isn't it?
my lord, I believe, my lord, I have been able to persuade to some extent my lords, and I've submitted my written argument as well, my
I
lord.
understand, but that is the final
because-
stage of hearing.
Yes.
No use of making it release.
My lord, no, because why I'm praying this is because, my lord, they have been taking adjournment of a couple of
We'll
times.
just
my
see.
lord.
We'll just see.
That's
Just
only
give
that's
him-
only thing.
Give him 1 more week,
1 week,
and then we'll just see.
my lord, oblige.
On prayer made by Mr. G. A. Petula. Please wait for the court to pass order. This is not the way.
Sorry. I'm sorry. My apology.
Just one prayer made by Mr. Arch. So, Learned G. A. What's the response? This is.
Supplementary cause list, item number 1.
This is again my gratuity matter of the District Council. I will take instruction, my lord. I am appearing for all the respondents.
You are a retired man.
Is retired. 31st December
No
2020.
service benefit release.
Gratuity and leave salary they used to
Gratuity and
get.
leave salary is the
There
only
is no
benefit.
pension. My lord, he retired on 31st December 2021. Then by annexure 2-3, Lordship. His gratuity and leave
Achha,
salary
it was sanctioned.
sanctioned.
Thereafter also not released.
Then annexure 5 and 6, Lordship, there is some discrepancy with regard to the amount. Then they have later on made additional amount by annexure 5 and 6, Lordship.
Hard. Interesting. Not counsel for the petition. Issue notice, she returned over the 3 weeks. Mr. Day appears for all the respondents. And hence,
Last 3 months.
no further notice is called for.
Stop. 5, 6.
The learned counsel for the respondent shall obtain his appropriate instruction in the matter. List after 3 weeks.
Must.
Daily list, item number 1.
Yes.
Your Lordship, I am filing power today for all the respondents except respondent number 1,
Who is respondent number 1?
N.B. Chaudhary.
He is not represented then.
Lordship, may I please, Your Lordship? Lordship, we're still awaiting status report, Lordship.
No, that is okay. Once he enters appearance, then status.
For
There is no.
respondent.
And the copy also you have not received all, Your Lordship. Only one person has received the copy.
Today we are dealing with the miscase, isn't it? There is an application for leave actually.
Yes, Your Lordship.
The appeal is yet to be admitted. Have you seen the office note?
Lordship,
Have you checked the office note? Did you verify the office note in the file?
no, Lordship.
You should have. See, notice it upon the respondent number 1 has returned unserved with a note that on the envelope address he moved. Address he moved. So you have to verify the address and you have to take steps.
Lordship.
And so far the other respondents, you will represent all the respondents 1 to 5. Oh, sorry, 2 to 5.
2 to 5, Your Lordship. They have not received copy, but I got the instruction because they got the information, Your Lordship. Actually, the case is
It's
very...
up to you. If
Yes,
you are
sir.
satisfied, if you have the power, then it's okay. There is no
Only
power.
I will request to supply the copy, that's all, Your Lordship.
We'll do that, Lordship.
Okay. Just say. Mr. Sharma, Land Council, presented appearance on behalf of the in the miscase. This in the miscase 54 of 2025. Has entered appearance on behalf of the respondent number 22226. However, there is no appearance on behalf of the respondent number 1. Full stop. The office note dated 15/7/2025 indicates that the notice could not be served upon the respondent number 1 as the addressee had moved from the place. Addressee had moved from the given address. Stop. The petitioner shall verify the address of respondent number 1 and take fresh step of service within how many days?
Lordship, 1 week, Lordship.
Within 1 week. Okay. The learned counsel appearing for the respondent number 2 to 5 submits. Next paragraph we just say, the learned submits that it is it required to be recorded, or they will give you a copy just like that,
Or
or
Lordship, they will give
No,
them
they will
the
copy,
record.
Lordship.
Right, Lordship.
you just supply them.
Lordship.
Okay. Just say, then just say list after 3 weeks. We'll have it after 3 weeks then.
Right, Lordship.
Meanwhile, you supply them the copy.
Lordship. Obliged, Lordship.
Deeply obliged.
Item number 2.
Last line is not required. Submit.
May it please Your Lordship. Your Lordship, the petitioners were supposed to produce some judgments, Your Lordship, in this matter.
Brief
What
us something,
judgments?
Your Lordship.
That is regarding what?
This is a civil revision, Your Lordship.
Yes.
They're coming against the order of the learned assistant judge, Your
Okay.
Lordship.
This is the order column, isn't it?
Yes, Your Lordship.
So the parties have appeared.
Yes,
here.
Your Lordship. Yes, Your Lordship.
So matter is ready, otherwise ready for hearing.
It was supposed to be for admission hearing, Your Lordship.
Is it?
Yes, Your Lordship.
No, this is in the order column. This is item number?
Item number 2, Your Lordship. Actually, we're
These are
objecting.
orders.
We're
not
objecting
an
the
admission
case on maintainability, Your Lordship.
That is okay. That can be.
So, Your Lordship, I pray for 2 weeks' time, Your Lordship.
But then there is nothing as such to list it for admission hearing. It's nothing. See, you want to file an objection or what? No.
No, Your Lordship. No, Your Lordship.
You will not file an objection.
Yes, Your Lordship. We will just argue, Your Lordship, on
You'll argue.
maintainability.
So
Your
we'll place
Lordship.
it for hearing,
Yes, Your
and the
Lordship.
question of maintainability will be kept open.
Yes, Your Lordship.
Okay,
Yes, Your Lordship.
that's all right. Okay, learned counsel appearing for the party submit. The matter is ready for hearing. Stop. Next, as prayed for, release this matter for hearing after when?
2 weeks, Your Lordship.
3 weeks, Your Lordship.
After
I pray for 3 weeks, Your Lordship.
3 weeks. After 3 weeks.
Yes, Your Lordship.
Stop. The question of maintainability of this revision petition is kept open.
Highly obliged, Your Lordship.
Item number 3.
Yes.
My lord, in this matter, we have already taken steps on the private respondent.
See, service report has returned unserved. So, what is to be done? Why it is unserved? No mark in the office. It is a link without instruction. Okay. It could not be solved. Probably address was not available at the time. So what is to, we will take fresh steps.
Fresh steps. In the meanwhile, the interim order.
There is only one respondent, isn't it?
Sole respondent.
Yes. The office note, the related office note indicates that the notice issued upon the sole respondent has returned unserved. Stop. The petitioner shall take fresh steps of service upon the respondent within
Within 3 days, madam.
within 3 days. This is matter after when? When shall we have it?
After 2 weeks, madam.
This is matter after 2 weeks.
Interim order may kindly be extended, madam.
Stop. The interim order passed earlier shall continue till the next date. We listed for 3 weeks. Yes, must just make it 3 weeks so that they can take steps and then.
Much obliged.
4.
Yes, Mr. Khureshwar.
Yeah, I have, if they're filing any objection or
If not, then matter is ready for.
Objection only if on the question of maintainability.
Maintainability,
Otherwise,
okay.
there is no scope of filing objection.
It may be
We are waiting for
faster for hearing.
instructions. We are waiting for instructions, Your
So
Honor.
you will enter appearance today.
Yes, Your Honor.
Okay. Yes, Mr. Sir. You have already
Already entered.
filed Pagalatnama. You file it. It should not be something like that. Then in one case we found
He's
that
not the
lawyer-
standing counsel. Standing counsel is SP Monta
Yes, Your Honor. He's
for the Contempt board.
So what is to be done?
Under instruction.
Can he enter appearance then? Anyway, we do not know. That is your problem. We'll just record. Just record his name. Standing counsel has entered appearance on behalf of the restaurant number 1 and 2.
Your Honor, we are responding only two, Your Honor.
Restaurant number 2.
Yes, Your Honor.
And then who is 1?
Then he's the same person. The Contempt executive officers and the state officer is the same person.
That is a department ultimately, isn't it?
They're the same person. He's designated as state officers. Same person.
The Shillong Cantonment Board.
Shillong Contempt
And
board.
the
and-
State Officer Cantonment Board is the same thing. What is the
Same
problem?
person.
Because, Your Honor, it's written only we are responding number 2. That's right.
No, but it's the same person. Because in the
You
lower
want to
court,
say your state officer is different from you?
but in the trial court, state officer is represented by SP Mohanta only.
See, he must be properly instructed, otherwise this is a problem. See, Mr. Lindo, see the
officer
respondents. See the
instructed by-
respondents. We fail to understand if you appear for 1, then why not for 2?
The file in this case, you representing him also.
We're representing both, Your Lordship, respondent number 1 and number
So
2.
you
My
just,
sincere apologies, Your Lordship.
See, properly instruct the
Yes, Your
counsel
Lordship.
whoever appears. Okay.
sincere
Just say,
apologies,
Mr. So-and-so, London counsel has entered appearance for restaurant number 1 and 2. And paid for grant of some time for obtaining necessary instruction. Prayer allowed, list after 2 weeks.
3 weeks, Your Lordship. It was
3
from the
weeks.
ministry.
Is it all right, Mr. Kurus?
Okay,
2 weeks. Please for
Obliged, Your Lordship.
Yes.
5.
Lordship,
Yes.
I am appearing for respondent number 6, Lordship. I need some more time to file my objection, Lordship. 2 weeks, Lordship.
No, 6 months. 1. You will enter appearance today only?
On the last occasion, we have entered appearance, Lordship.
Okay.
Both
You have
5 and
already.
6.
ADCM had entered appearance on the last occasion. So what is your prayer today? You will not file any objection. And then what about others?
I will file, Lordship. Respondent number
You are a number 6 you will find. And what about 1 to 4?
1 to 4, my lord, the state respondent. So we will be producing, my lord, the status report of the FIR, my lord.
So you will not file any objection. Okay. Just say Mr. Well, just say record his presence for the petitioner. Then you say Mr. Singhan Learned G appearing for the restaurant number 1 to 4 submits that no objection will be filed, no written objection will be filed with the state in this matter. Stop. Similarly, MS ADCM London Council appearing for the restaurant number 5 also submitted that the restaurant number 5 also will not file any objection. Not file any written objection in this matter. Stop. MS Jetty Sangma Lord Council appearing for the restaurant number 6 place 4 and is granted
Yes, 2 weeks time.
2 weeks time for filing affidavit in this matter. List of 2 weeks. Yes. After 2 weeks?
Yes, deeply obliged.
6.
Yes.
Lordship, I'm praying for 2 weeks' time, Your Lordship.
You're for respondent?
Number 5, Lordship.
On the last occasion, you did not appear.
Lordship, yes, I was unlexed before the
What is
other
this
bench.
matter about?
This is regarding the pension, my lord.
Pension.
I have received instruction, Your Lordship.
Okay, and what about state has filed?
Lordship, I'm making similar prayer on behalf of the state.
So we'll just give you time for filing. Let them file their counter affidavit. Yes. The learned MS Jet Nongrendi, learned G appearing for the resolution number 1 to 4, and MS Passa, learned counsel appearing for the resolution number 5. Pray for grant of some time for filing counter affidavit. Prayer allowed. List after
3 weeks.
2 weeks.
Item number 9.
Similar prayer, Your Lordship.
9 also similar, same lawyers and same respondents.
Yes.
I'm for responding.
No,
for
here you will be 1 and 1 to 3.
3.
Here will be same thing. The MS Nongrendi will be for 1 to 3 and MS Passa will be for 4. Okay, there is no 5 here. And otherwise same thing. Yes.
10.
Similar prayer, Lordship. I'm for respondent number 6 in this matter.
10 also is there. Same matter.
Yes, lord. Same matter.
Okay. Okay, there Mr. Pala will be for resolution number 1 to 5.
Yes, Your Lordship. I'm for
And-
respondent number 6.
You will be for 6.
Yes, Your Lordship.
So there is a variation of the number of respondents.
Yes, Your Lordship.
So same thing, only just challenge it. 6. Give 2 weeks. Not at 2 weeks time for filing this thing. Yes.
11.
Obliged, my lord. Lordship, I'm
Yes.
praying for some time to file my affidavit in this matter, Your Lordship.
Speak louder, you see.
Praying for some time, Your Lordship.
For
Filing my affidavit.
this is also service thing.
This is
Lordship.
service matter. Retirement benefits, Your Lordship.
Okay, so we'll give him time. One prayer made by Mr. Impala and G. Appearing for. There is no private respondent.
Sorry, Your Lordship.
There is no private respondent.
No, Your Lordship.
Appearing for the respondents. 2 weeks time.
2 weeks, Your Lordship.
2 weeks time is granted for filing counter affidavit in this matter.
12.
Yes.
Obliged, Your Lordship.
Obliged, Your Lordship.
Lordship, we are seeking further time to file the affidavit, Lordship.
One prayer made by Judicial, learned senior G. Appearing for the state respondents. Further, how much time?
3 weeks' time, Lordship.
2 weeks time is granted for filing counter affidavit.
Much obliged, Lordship.
13.
The state has to obtain
My
instruction.
lord, I'm awaiting instruction, my lord.
You are still awaiting instruction.
My lord, yes.
So how much time? will
My
be
lord,
ready?
lordship can kindly give me further 2 weeks time, my lord, to have instruction.
Just one prayer made by MSR Corner, learned G.
For all the respondents, my lord.
Appearing for
My
the
lord,
respondents.
One submission, my lord.
Just-
In the meantime, my lord, the records may be bring.
Let us see
No,
what
my
comes
lord,
up in the
affidavit
thing.
has to come first, depending on the lordship
Why you
can.
want to put the cart before the
My lord,
horse?
yes.
Huh?
Oh, my lord.
Just wait. Let
Because
the
there is
reply
a-
comes. Who knows? It may be in your
Yes,
favor also.
Yes, my lord, that is true. my lord.
State may not be adverse to your interest always. State has a duty to do the needful,
My
isn't it?
lord.
See, normally you don't think the state council will come with unnecessary objection.
No,
If department
My lord.
agrees with what you say,
my lord. is
yes. So there is wait.
My lord.
Okay, just this. How much time you'll be needing?
My lord, further 2 weeks time may be
Further 2 weeks
granted.
time is granted for. Just say 2 weeks. Just don't say further. 2 weeks time is granted for counter evidence. Yes.
Highly obliged.
Hearing item number 16.
Yes, Mr.
Lordship, this is that Lordship Section 482 application, Lordship, regarding Drugs and Cosmetics Act. In fact, on the last occasion, your Lordship had told us to check the written submissions because Lordship written argument has already been filed. So we were supposed to check it, Lordship.
Argument was filed before
Yes,
this
Lordship.
court.
So we have checked it. These are on similar lines, Lordship. We are arguing. So
There's a written argument already filed in this matter.
Well, that had been filed when Mr. Kaur was leading in this matter.
So not before this court at least.
No.
It's long back, quite
Way
some
back,
time back.
way back.
Yes. So that is everything is all right about that.
More or less, it's in similar lines.
My lord, may I say, if the matter can come up next week, my lord, because the counsel with the brief, Mr. Kharwalang, is on legs, my lord, so a bit difficulty is faced.
And there always remains this kind of difficulties. Yes, Mr. Paul.
There's some difficulty.
But the next week, you do not know after 1 week how the roster possible after a week. Then we'll
Next
have-
week.
Okay, on prayer made by Mr. M. Sangupta, Lana Council appearing for the state respondents. This is longer.
Copy of that, right?
After a week.
Well, may I crave for an indulgence that written argument which has been filed, Malaj, we don't have a copy in our file. Well, if my lords direct, a copy is kindly provided to us, Malaj. I can assist your lordships on that.
You want your copy of your
Malaj,
thing. Anyway.
little difficulty because of the change of counsel.
Okay, it is next paragraph. We just it is submitted by the London Senior Counsel that the written argument submitted on behalf of the petitioners in this matter on 1/4/2021 has been misplaced.
Written argument.
From his record, from his personal record, from his personal file. The London Senior Counsel, therefore. But then, is it not that you can apply for a copy of this and you get it?
Yes.
Well, it's just a written argument, not part of the pleadings, Malaj. There might be some difficulty at that stage.
But then once it is there in the record, you have to get a certified copy. It is kind of a document now.
We could do that also, Malaj, but that again will take a little bit of time, Malaj. If it just falls for my lordship,
Maybe
Malaj.
consumption of the same thing. Anyway, what is it? No, just don't say London Senior Counsel. It is submitted by so-and-so, then give a full stop in view of the submission made. Now we cannot direct the registry to give you a copy.
We will apply.
You have a copy of this?
No, we also will apply.
Malaj, nobody has a copy of that. That is the difficulty.
We will apply and we will provide them.
But can be given to us at our cost, Malaj. We can pay the
That
cost.
is all. That comes to the same thing. You apply for a copy.
Malaj.
So then nothing. This
Malaj, my only difficulty is that sometimes what happens is, Malaj, when it's outside the pleadings.
Just cancel this thing. It is just you say it is submitted by the parties that the written argument submitted on behalf of the petitioner, which is a part of record, has been misplaced. The parties after Pushubda, you say the parties as such shall have a liberty to apply
from the registry.
Malaj, that will take.
Apply for a copy of the written argument submitted on behalf of the petitioner. That is all.
Yes, ma'am.
The difficulty is, Malaj, sometimes on the registry there's an objection that it's not part of the pleading, so they
Actually, it should not be. So
Should
once
not be.
something is there in the record,
should not be, Malaj. But
even it is a list of books. That
Malaj,
was
the difficulty is that is the view that's taken there.
anyway.
But
we'll
sometimes,
work it
Malaj, what happens is in these written arguments, Malaj, my lords make some notes. So probably because of that,
That is handwritten part of the code. That is you should not get it.
Lordship,
But that
that
is a
is
written
why
argument
probably,
submitted.
Malaj, I had explaining that probably why the registry is a little circumspect in giving the copies of the written arguments. I'll oblige.
18.
Yes. Yes, Mr. Joshi.
May I please, Lordship. Lordship, this is the amendment petition that we have filed because during the course of subsequent development has taken place. As my my appeal was pending before MHA, and the respondent has taken a plea of.
You filed an objection to that.
Yes, Lordship. But nothing as such has come on that objection. Also, rather, it's kind of suggesting that you withdraw this writ and file it afresh. So, if your Lordship may have their reply, Lordship.
If you give undertaking that, what is the stay about?
Stay was about the bail. The petitioner here is on bail, Lordship, and during the course of the time he has filed a representation before
We'll
MHA.
allow him to withdraw it and file afresh, provided you allow him to remain on bail. Till petition, we will give him certain time to file it. We will say that if no petition is filed, fresh petition is filed within that period, then the bail granted to him will stand automatically cancelled. Are you agree with it?
Lordship, I have no instructions
So
regarding
you
that,
should
Lordship.
see, if you take some stand, you must be ready with those. The only thing is that, you see, normally probably this court also was initially had taken that view that you file afresh. But then his difficulty is that the interim order passed here. If he withdraws, that interim order will go. But then it is a grant of bail, isn't it?
Lordship.
Is it a grant of bail, isn't it? In pursuant to the grant of the interim order,
Yes, Your Lordship.
you have been granted bail,
Yes, Your Lordship.
isn't it?
Yes,
Is it correct?
Yes, Your Lordship.
So if you are correct, you can pass an order saying that this bail granted to you
Yes, Your
by virtue of the interim order passed by this court will remain operation for certain time.
Yes, Your Lordship. That also can be done. But as such, Lordship, I am not seeking any.
See, instead of making this thing voluminous and complicated,
Yes, Your Lordship.
that would be a proper suggestion. If you agree to that.
Provided if I am allowed to continue to go on bail, then that.
But then certain period doesn't
That's a
mean
lot.
that you
That's a
will
lot.
withdraw and then will. That will be a ever thing.
Exactly.
When was this interim order passed? Can we do that, madam? Or
Lordship, I'll just seek some instructions, Lordship, regarding that.
next week?
Lordship.
We'll just sit with them. When was this interim order passed?
Interim order was passed on. June 2nd, 2022. That's this is the 2nd of June 2022. Lordship.
2nd of June 2022.
Yes, Your Lordship.
Authorisation in this case.
Yes, Your Lordship.
Yes, this is a simple kind of instruction. You just take instruction and then we'll just. Just one prayer meet. Just write in the miscase number 2 of 2025. Just one prayer made on behalf of Dr. Majika, London DSGA. This is matter. After a week. And in the main case also, you just say list along with miscase number so and so. Okay? It is in the previous order of the thing.
Deeply obliged.
Actually, this matter, Mr. Keshav Gautam is there. He is having a hearing matter in court number 2.
Yes.
He may be taken up to 2 weeks, Lordship.
No problem.
No problem.
Okay. One prayer made by Mr. H. Karmi, London Additional PP. Appearing on behalf of the respondents. He appeared for all the respondents.
All respondents.
This is matter after 2 weeks. Yes.
22.
May we please, Your Lordship?
Yes.
Lordship, this is a case related to 354 case, Your Lordship. It's a criminal revision petition, Your Lordship.
Okay, that is that matter.
Yes, Your Lordship.
Settlement.
Settlement. Your
After the
Lordship.
conviction.
Yes, Your Lordship.
Yes.
Your Lordship,
We got stuck at what point?
we got stuck at whether after payment of fine, can the fine be refunded or not, Your Lordship?
No, yes.
For that,
And if
Your
it is
Lordship,
not refunded, then what is the implication? Yes.
for that, Your Lordship, I would like to rely on Patna High Court full bench, Your Lordship.
Yes.
Your Lordship, in this case, the accused persons, Your Lordship, were acquitted by the trial court, Your Lordship, and thereafter the state government preferred an appeal before the High Court, whereby the High Court upheld their conviction, Your Lordship, and thereby they were made to pay the fine.
Upheld.
The
Trial court acquitted.
Acquitted, then
There
it
is
was
no question
reversed.
of High Court upholding the conviction.
No, it was
High Court
reversed.
overturned it.
Oh,
and
you
convicted
overturned it,
them.
Your
Yes.
Lordship. Thereafter, Your Lordship, the accused persons in this case, Your Lordship, they preferred an appeal before the full bench, Your Lordship, whereby, Your Lordship, the full bench overturned and acquitted the accused persons, Your Lordship. And also, Your Lordship, I would take Your Lordship to para number 56, Your
What
Lordship,
does it say? Just say.
with regards to the fine, Your Lordship.
Yes, para 56.
56, Your Lordship. The point referred to the full bench is answered in that way that in excess of
So
power.
that is a reference to the full bench. It is
Yes,
not
Your
that the accused has preferred an appeal. to
Yes,
the
Your
full
Lordship.
bench.
It was a reference to the full
So
bench.
you must be correct in facts because your submission has a bearing. The court must understand from your submission.
Yes, Your Lordship.
Yes.
If I may be allowed to read, Your Lordship.
Yes, please read, but then place the things correctly. Yes.
The point referred to the full bench is answered in this way that in exercise of the power under section 423 clause 1 subclause B of the CRPC, the appellate court cannot alter the finding of the trial court so as to convert the acquittal into conviction in cases not falling under section 237 so and so of the CRPC. In circumstances, the order of the appellate court convicting the petitioners so and so under section 147 of the penal code, of which they had been acquitted by the trial court, cannot stand and is set aside. Their fines, if paid, should be refunded. The conviction of the remaining petitioner under section 313 of the penal code, which has been upheld by the Court of Appeal, will stand as there is no error in pointed in law out to us with regard to their cases, Your Lordship.
See, there is a difference. There the conviction was overturned.
Yes, Your Lordship.
Because of some legal reason. Here we are acting on the basis of this thing, of the basis of compromise, settlement.
Settlement, Your Lordship.
This doesn't, attribute to the elite. See, the settlement would definitely not make this conviction order illegal.
True, Your Lordship.
So situation is different. Now probably, like if you do not insist on the refund of this money, then we may.
We will not insist on the refund, Your Lordship.
This court will not pass any order on refund.
Yes, Your Lordship.
If it is simple overturn, by holding the trial court's order
Yes, Your Lordship.
as illegal, you are entitled. But then here, the case which is put forward by you in this court
Yes, Lordship.
is basing on compromise.
Compromise,
Not
Your
on
Lordship.
merits.
Not on merits, Your Lordship.
And you have
Cited
supported your submission by the Apex Court decision.
Apex
to
Court
some-
decision, Your Lordship.
Yes, Mr. Kharmi.
He's not insisting on the refund, and he is relying on the Supreme judgment regarding the compromise after the conviction. So that judgment is it's covering.
So you have no objection to the acceptance of the settlement?
Yes, Lordship, because he is supporting it with the judgment.
That is up to you. Whether you dispute or do not dispute, this is
No, we are
your right.
We are because we are not disputing it, Lordship, and
Yes.
we can dispose.
So you will not get a refund of.
No, Your
He's
Lordship.
not insisting it.
We're not insisting, Your Lordship, on the refund.
What is the order of conviction?
Order of conviction is at page of 68, Your Lordship, of the paper book. If may I be allowed to read, Your Lordship.
Page 60.
68, Your Lordship, of the paper book.
You do not have to read the entire thing, just let us first take note of the things. Page
68, Your Lordship, of the paper book.
Yes. This is a compromise. Page
No, this is the order of sentence, Your Lordship, page 68.
68.
68 is the order of sentence, Your Lordship,
68 of the order of sentence means?
of the paper book. The
Not
punishment,
your
Lordship.
petition.
No, of the paper book, Your Lordship, paper book.
Okay. Yes.
I hereby sentence the accused to rigorous imprisonment of 1 year and also payment of fine amount of rupees 10,000 for section 354. In default of payment of fine, the convict is hereby to undergo further imprisonment for 1 year 3 months, which is 1/4 of the term of imprisonment for section 354, in addition to the rigorous imprisonment of 1 year, which shall be in total of 2 years 3 months if one run after the other.
Where do you get the factual background of the case, Mr. Limler? The facts of the case.
Facts of the case is at page 91, Your Lordship. Of
Page
the paper.
91.
And it's also 13 minutes.
And what is the finding of the appellate court?
My Lord, if I may be permitted to read, Your Lordship. Your Lordship, in this case by the appellate court, Your Lordship, the finding is that in this case,
The
Your Lordship,
operative part only. Where it is? Where is the order of the? Where is the order of the appellate court?
if I may read from para number 7, Your Lordship.
What page? Where is the page?
The judgment, Your Lordship.
Anyway, it's okay. Just sit down. This court will dictate. Just see if if something goes wrong, point out.
Yes, Your Lordship.
Okay. Yes. And Mr. Linder, Learned Counsel, for the petition, and also Mr. H. Karmi, Learned Traditional PP, appearing for the state respondent. Stop. Paragraph. By this revision petition, the petitioner has challenged the impugned judgment and order dated 21/7/2023, passed by the Learned Chief Judicial Magistrate in GR case number 11 of 2022. And also the impugned judgment and order dated 11/7/2024, passed by the Learned Session Judge in Criminal Appeal number 2 of 2023, whereby the petitioner was convicted under Section 354 IPC and was sentenced to rigorous imprisonment for 1 year and a fine of rupees 10,000. And in default, to undergo additional simple imprisonment for further 3 months. He got it. If simple imprisonment for additional 3 months, you will get it in that petition. Okay. And as well as in the paperwork also, in the phlegma part, even from the cost title also you can get it. Paragraph. The brief fact of the case is that an FIR was lodged by the respondent number 2 before the William Nagar Women's Police Station on 2/4/2022, alleging that the petitioner had outraged her modesty. Step. The said FIR was registered as William Nagar Women PS case number 06 within bracket 4 2022 under section 354 IPC. Stop. And the matter was investigated. What do you say? Just say the said FIR was registered as so and so. Okay. And matter was investigated into. Stop. Give a stop. Upon completion of the investigation, a charge sheet by CS number capital C capital stop number CS number 07/2022 dated 2011.
My lord,
This
I
is
would like to
this
correct
is-
the charge sheet, your lordship. It's dated 7/5/2022, your lordship.
So why you have given wrong date here?
Typo mistake, your lordship. My sincere apologies, your lordship.
7/5 7/5
2022 at page 13, your lordship. Charge sheet.
7/5/2022. Just tell us the last line after up. Was filed, was submitted, and the petitioner was put to trial in GR case number 11/2022. Before the Learned Chief Judicial Magistrate. Before the court of the Chief Judicial Magistrate. Which place? Chief Judicial Magistrate of?
East Garo Hills, Your Lordship. East Garo Hills, William Nagar.
Chief Judicial Magistrate, William Nagar. Upon completion of the, don't say upon completion, at the learned Chief Judicial Magistrate. You don't say, you just say at the trial. Just say at the trial. Just cancel it. After full stop, you just say at the trial the petitioner was found guilty by the trial court and was convicted by impugned judgment and order dated 21/7/2023 and was sentenced to undergo 1 year's rigorous imprisonment along with the fine of rupees 10,000 and in default to undergo further simple imprisonment, further simple imprisonment for 1 year. Oh, for 3 months, not 1 year. For 1 year, 3 months.
Yes, Lordship.
What is for 3 months? What's the problem, Mr. Lindo?
Page 68, Your Lordship. 1 year, 3 months, Your Lordship, at page 68.
1 year is under. Oh. 1 year, 3 months.
1 year, 3 months, Your
So on the top also probably we have written only 3 months. So it should be 1 year, 3 months. Okay, it means altogether it is 2 year, 3 months. If
2 years,
the
3
event
months, in the event of which I didn't pay my fine, Your Lordship.
that means he has already served his sentence.
Yes, Your Lordship.
Then what is the purpose?
Lordship, for
Anyway, he's out already.
he's out, Your Lordship. No.
What purpose will be served by this?
Yes, Your Lordship.
What purpose will be served by
Your
this?
Lordship, if I can be reinstated.
The sentence.
Yes, of the sentence, Your Lordship. Just
Then it has-
last, just 2-3 days back only, Your Lordship, he was out. So, Your Lordship, just if he can be reinstated back in service,
That
Your
is, this
Lordship.
court cannot do anything. That is
not
what, not is for this court to see.
different subject.
It is not for
Reinstatement.
this court to see.
Yes, Your Lordship.
We do not know what you are doing. What is your intention, real intention also. Anyway,
It has become fractious.
just can you say that
That
at the
means
trial?
it has become fractious, Lordship, this matter.
Anyway, since he may have something like the stigma of being convicted, that may be to some extent removed. Okay, so what purpose it serves, we would not know. We will just see. Let us see. And was sentenced. Uh, 3 months. Stop. On appeal, the judgment on appeal, the conviction. On appeal, the conviction of the petitioner was upheld by the learned session court. William Nagar session judge also is William Nagar. Learned session court, William Nagar. By judgment and order dated 11/7/2024. Passed in criminal appeal number.
Criminal appeal number 2 of 2023. Sessions case criminal appeal number 2 of 2023.
Criminal appeal number 2 of 2023. Stop. The present the petition has filed the present revision assailing the just after full stop you say assailing the aforesaid judgments, aforesaid assailing the aforesaid judgment, the petitioner has preferred this revision application. Before this court. Stop. Give a paragraph. Mr. Lindo, learned counsel appearing for the petitioner without referring to the merits of the case has submitted that the petitioner and the respondent number 2 has compromised the matter between them by where is the settlement date?
At page 192 of the applicable book, Your Lordship.
192.
Yes, Your Lordship. Typed copy is at 193, Your Lordship.
What you say? It has have not has have compromised. A deed of compromise dated 27 March 2024. Your compromise is basically not to pursue against this thing. So once matter has ended, what is the question of pursuing it? Has compromise, okay, and settled. What is it? Just last line. The and at present there exists no difference between them. Stop. The learned counsel further contends that the respondent number 2 it does not hold any further grievance against the petitioner and in the fitness of justice it would be appropriate for this court to set aside the conviction of the petitioner on the basis of the compromise. Stop. In support of his contention, the learned counsel has placed reliance on a decision of the Apex Court reported in 2013 14 SCC 577, P. Ramaswamy versus State. You just see from here. I'm just write it down. Okay. What is it in support of so and so? Mr. Counsel has written so and so and submitted that. In similar situation, the Honorable Apex Court has interfered with the has set aside, has set aside conviction on the basis of the compromise between the complainant and the accused. Stop. He therefore submits that the similar benefit may be extended to the petitioner in this case, and his conviction may be interfered with. Stop. Paragraph. Sit down, Mr. Mr. Next paragraph. Mr. Karmi, learned additional PP, appearing for the state respondents, has not objected to the prayer made on behalf of the petitioner and submitted that since the Apex Court has allowed such prayer on the basis of the compromise, the petitioner may be given similar benefit. Stop. Next paragraph, Mr. Yes, just record is Mr. C.K. Marak. Mr. C.K. Marak, learned counsel appearing for the respondent number 2, supports the submission made on behalf of the petitioner and submits that a compromise stroke settlement has indeed been arrived into between the petitioner and the respondent number 2. And the respondent number 2 is not interested to pursue the matter anymore. Stop. Next paragraph. Having heard the learned counsel appearing for the parties and on perusal of material of record, it appears that the petitioner and the respondent number 2 have amicably settled the difference and dispute between them by executing a compromise, by executing a deed of joint compromise dated 27 March 2023 between them. You have not filed any affidavit in this matter, isn't it? Have you filed? No. Where is that? Yes, 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 yes. Yes. It's okay, sit down. What is the last time? Okay, stop. Further, the respondent number 2 has filed an affidavit dated 4/7/2025 before this court, affirming that she always wanted to compromise the case as the misunderstanding between her and the petitioner arose due to language barrier. And the petitioner being a villager had no proper understanding of Hindi language. Stop. It is further asserted by the question number 2 that the settlement stroke compromise has been arrived at voluntarily. And the deed of compromise was signed in presence of relatives of both the parties. Stop. Give a paragraph. In the case of P. Ramaswamy, P. Stop Ramaswamy, Supra, you just say. Supra, the apex court, in similar situation, the apex court granted relief to a convict on the basis of compromise entered into by the parties. In an offence under section 354 CRPC. Stop. It appears that the situation involved in the said case was more or less identical to the situation in the present case. Stop paragraph. Just in view of the above, this court deems it appropriate. This court deems it appropriate to adapt the to allow the prayer made by the petitioner in this case by adopting the similar line as in the case of that P. Ramaswamy Supra case. Stop. Give again paragraph. You just say in the circumstances without going into the question. As to the legality and correctness of the conviction of the petitioner in the criminal case, the petitioner after comma, without going this comma, the petitioner and the respondent number 2 is permitted to compound the offence under section 354 IPC, for which the petitioner is convicted. Stop. The said offence shall stand compounded. Stop. As per the after full stop, the composition of offence shall have the effect of acquittal in the case in terms of section 320 subclause within bracket 8 CRPC. We do not know what benefit we will get of acquittal at this stage. Anyway, the after full stop, the petitioner, comma, as such, comma, is acquitted of the charge under section 354 IPC. Stop. Resultantly, the impugned judgment and order dated so and so passed by the learned Chief Judicial Magistrate in such and such thing, and impugned judgment order dated so and so in session criminal appeal number so and so by the session judge so and related order of sentence are set aside. Stop. Next paragraph. This revision petition stands disposed of in the aforesaid terms. Stop. There may be correction here, there, bit here, there, and all those things.
Obliged, Your Lordship. Deeply grateful, Your Lordship. Deeply grateful, Your Lordship.
You see, when you place matter before court, please try to place it correctly. Otherwise, you end up confusing the court.
Yes, Lordship.
Confusing court would not give you any benefit.
My sincere apologies, Your Lordship.
There is a miscase also here.
No miscase. For bail, it was there, Your Lordship.
Okay. This miscase in view of the order passes so and so. Same section disposal. Miscase 117. Dispose. Where is the basket?